Today's topic is legally accountable. What should endorsers, influencers, celebs know about the CCPA guidelines? We have with us on our August panel Mr. Bishwajit Dubey, partner Cyril Amarchand Mangadas, Ms. Namita Matthews, partner Argus Partners, Solicitors and Advocates, and Mr. Vinay Bhutani, partner Economic Laws Practice. A very warm welcome to you, panelists. I'm your host, Ashima Ori, Managing Editor of BW Legal World, along with our editorial lead, Costa Mehta. Together, we hope to get you as many insights from our experts in the next hour. Very warm welcome to our audiences as well, joining us across various platforms. We dive right into the conversation and starting with Namita. Namita, what are these new guidelines for prevention of misleading advertisements and endorsements issued by the Central Consumer Protection Authority? Your views, please.
Ashima, you've actually just said it in what you said. It is actually guidelines to regulate false and misleading advertisements in India today. Effectively, the purpose is to provide a framework as what is valid advertisements and what are false and misleading advertisements, and categorize it effectively to provide a framework of regulation of what is permissible to be advertised, whether it is by the manufacturer or the vendor or maybe social media, anyone who works in the social media space. So it is effectively that scope that has been provided. And for the first time, it extends to all platforms, whether it be television, print, social media, any form of platform which propagates or publishes advertisements, and including the partners who are involved in this scope.
Right. Thanks, Namita. We'll come back for more on this. Coming to you, Vinay, how do these guidelines change the current landscape? What are the gaps they're aiming to fill?
See, I think advertisements have played a pivotal role in enticing customers for sale of goods and services. Before these guidelines were notified, misleading advertisements from a consumer protection perspective, vis-a-vis the rights of the consumers to seek redress, were in a way governed solely by the ASCII code, which is more like a toothless tiger, right? Now, in 2019, when the Consumer Protection Act was notified, the central government identified the importance of true and honest advertisements and introduced the concept of misleading advertisements, and also gave reference to endorsers, whilst obviously back then the term endorsers were not defined under the Act. I think especially with the impact of digital marketing, influencer advertisements, and celebrity endorsements, it is essential that there is a legally binding framework which mandates a company to take responsibility. Such binding effect is now created with these guidelines. Further, with the e-commerce being the go-to mode for consumers to purchase goods and services, the guidelines now also address the bait and free claim advertisements, which were being exploited, if I were to sort of say, by companies on e-commerce platforms. Again, the wide coverage of these guidelines, that is, covering advertisements in any formats and mediums, stringent penalties which can be imposed by the CCPA under the Act, will reform the way how advertisements are now being made.
Right. Thanks, Vinay, for giving us this insights. Bishwajit, coming to you. How will, taking from what Vinay said, how will they really essentially impact the social media and the advertising world, in your opinion?
Thanks, Ashima. So as there is now a proper guideline as to what is valid and how do you go about various kinds of advertisements, so there is some sort of certainty around it. It will definitely impact all the stakeholders, which includes the manufacturers, the service providers, the advertising agencies, the endorsers. Now they will know as to how to go about advertising any of the product or their services. They will know the contours, broad contours of where to go, how to go, where not to go. So it will have a major impact. And even for people who feel that they are aggrieved with some sort of advertisement, they have been cheated or they feel shortchanged for whatever reason, even they would know as to how to deal with it. They will have a forum to deal with it. They would know how to go about it. So I would say that this is a welcome thing with bringing in some level of certainty, and all these stakeholders now have a forum and procedure to know as to how to move forward.
Right. Thanks, Vishwajit. Right. We were pretty much in the wild before this. These guidelines really came through. Namita, coming back to you, more on, who needs to worry about these guidelines or kind of take, recourse to them. Does this extend to celebs, social media influencers, ad makers, e-commerce? Who else, who else needs to comply with these guidelines?
So Ashima, actually these guidelines cover almost every stakeholder that is involved in the advertising spectrum. It includes the manufacturers, it includes the service providers, it includes the advertising agencies that actually make these advertisements. It includes including all endorsers, and endorsers has been defined as anyone who actually publishes or creates any content, or anyone who has influence. So that would cover social media influencers, it would cover celebs, it would cover anyone who has influence over a consumer's mindset. So effectively, by the way it has been structured, it would cover everyone from the spectrum, including the platforms that publish these advertisements. Because the way it has been structured is the penalty clauses even extend to any platform or person who is publishing or participating in the act of publishing these advertisements. So in effect, it is anybody and everybody who is going to be, involved or profiteering from this entire enterprise, or even, creating anything which is known as an advertisement.
It's, there's also something on social media called affiliate marketing, where you're not necessarily already making profit, but maybe once that product is sold or something. So even all those people get come under the umbrella of these guidelines.
See, affiliated marketing will be a tricky question, because the question would be that whether they are actually involved in the participation of making the advertisement and promoting the advertisement. Yes, the question will arise that if they are ultimately benefiting from the advertisement and they're profiteering, or they are involved as a stakeholder in achieving something out of this, they might come within the guidelines, but it will have to be tested in waters, because the question will be that if they're actually not involved with the advertisement and they don't come within the confines of what is provided, though they might even come under the confines of what a service providers, because they're providing a service which involves the entire spectrum of advertising. So it'll be interesting to see how that comes along.
Right. Thanks, Namita, for that. With that, I also have a question on what could be the legal consequences for non-compliance. Vishwajit, to you, where will this take us? What happens if so many people don't know about it? All of a sudden, there is non-compliance. What then?
Yes, I think that's the most important question. So to answer that, I'll divide it into two parts. One is the procedural part of it, and the other is what is the real consequence of non-compliance. So number one, the procedural part is, now there is a central consumer protection authority, which is the agency which has been given certain powers to look into all of this. It's now like a regulator. And it has got wide power. So tomorrow, for example, I am found to be violative of this, and they believe that there's some material against me. So they have been given powers to investigate. They have been given powers to do search. They have been given powers to seize. So you will have to undergo, they may call you for questioning. So they have been given powers to run through the process to come to a conclusion whether you are in violation of any of the provisions of the Act and the guidelines. That's the first part of it. So one has to be careful and mindful that you have someone who's now looking after you directly. So you are, all of us who are in this, who are stakeholders in this, are under the radar. That's number one. Number two is what if you are ultimately found to be violative, right, of something? Then the consequences can be severe for all the stakeholders, and it would include, first, if there is a first violation, then the penalty can be up to 10 lakhs. For the subsequent violations, it can go up to rupees 50 lakhs. That's the monetary penalty, which I would say that something that a lot of people may not be worried about. But the second part is something that is more serious, and from the endorser's perspective, is that they may even be barred or banned from endorsing any product for a period of 1 year in the first instance, and which may be extended up to 3 years in the second instance if you violate it again. So in my thought that it was important to have these kind of clauses. It may seem to be a little harsh to begin with, considering that we were operating in vacuum at some level. But as if you are an endorser, if you are an influencer, you hold a lot of power over the decision-making process of people. People follow you, people copy you, at times by application of mind, at times without application of mind. So, and of course, more often than not, you're paid to endorse some product, so, or some services. So a responsibility has been cast on you. And with that, if you are violating that responsibility, you're also accountable and you're also punishable. So you have to be careful, and you know that in advance that this can be the consequence. So you take that responsibility very, very seriously. Otherwise, there may be consequences, and the harshest consequence could be that you are actually banned from advertising or endorsing any product in future. So I think, and plus you have the certainty now that you know that this can be the possible consequence. So you better be careful. So I think this is what is the consequence of any violation.
Right. And where would the recourse lie? To which forum, to which court?
So this is as I said, the agency is Central Consumer Protection Authority, and it will go to the consumer forum.
All right. All right. Thanks, Vishwajit. Kaustubh, over to you for more.
Thank you, Ashima. Great exposition so far. My question would be to Vinay. So, Vinay, what is a non-misleading and valid advertisement? If you could elaborate on that.
Sure. So I think, it's an easier way to sort of understand first what is a misleading advertisement. And by virtue of, these guidelines now coming in, it's in a way sort of expanded the definition of what those advertisements which are misleading in nature may tantamount to. And the background behind this is that whilst the Consumer Protection Act defined what a misleading advertisement is, the rules or the guidelines, if I may to say, are now saying what may not amount to non-misleading. Now, the guidelines list the characteristics / standards of advertisements, which are not considered misleading, and thus sets out the indicative guidelines for advertisements. That is also to state that in the instance of an advertisement that does not meet such characteristics or standards set out in the guidelines, as a matter of exclusionary principle, such advertisements may be misleading. Therefore, in my view, the definition of misleading advertisement gets expanded vis-a-vis the characteristics. And under the guideline 4, effectively what it spells out is 7 instances that may tantamount to what may not get categorized as non-misleading. So as long as it is truth and honest representation, as long as it does not exaggerate the accuracy or the scientific validity, usefulness, or as long as the consumer rights under the law are not presented as a distinctive feature, or as long as it's not suggestive any claims as universally accepted where the opinion is divided, so on and so forth. So basically, the easier way to look is first look at the definition of what is misleading, and effectively what is what does not come within the purview of misleading is a non-misleading advertisement. But by virtue of certain more additions in non-misleading advertisements, the definition of misleading itself has got a bit more broadened.
Do you think there must be any clarificatory guideline further?
No. So again, I think what needs to be read from the perspective, and every company or every stakeholder in this should first effectively read what tantamounts to misleading advertisements. And so long as you're sort of not checking any box within the misleading advertisements, you should then sort of run through what box you are falling within it not being construed as non-misleading. I think once that is clear, then you're in a much more safer space.
Right. So my next question would be to Namita. Namita, what should advertisers and endorsers know about bait, surrogate, and free claim ads?
So bait advertisements are actually advertisements which effectively try to sell goods, products, or services at a lower price to attract customers. So what we see is that, what is a product which is 100 rupees is being sold at, let's say, a slashed price, 50 rupees cost, saying that this is a short-term sale, buy it, etc. That is the purpose of what a bait advertisement is. Now, what they cannot do now, which is what has been defined, and bait advertisements have been around for, I think, most part of when advertising has always been there, is that they cannot, first of all, sell the product or the service or the goods unless they have proper supply of those goods. Because the moment you create this flux of, a drop of price, there's immediately an increase of demand, which is natural with any product that you sell. So that is exactly what happens with bait advertisement, is that the moment you say, I'm going to sell it at lesser price, you'll have more customers attracted. The first requirement that they have is that whatever goods or services you are trying to promote as being at lower price must first of all be available. So you must have sufficient supply to meet this demand that is going to be anticipated. And the advertiser is required to ensure that you are going to meet that demand at any point of time. Second is also, of course, the fact that in case you are able to see that you're not going to meet that demand, then it becomes the obligation of the advertiser. And what is important, the word advertiser is not just the advertising agency, it will also include the manufacturer and include even anyone who designs the advertisement or displays the advertisement. So also a social media influencer will also have to clearly state that if this is not going to be available, then by when is it going to be available? Okay, what are the timelines within which these products are going to be available? And you also will have to show very clearly as to if it's limited stock, then you need to display it, that the stock is limited. So these are some of the basic guidelines which need to be maintained now under bait advertising. Now, when we come to
just to come with a question there, so would this also apply to, say, an e-commerce catalog that you see, and they have these flash sales and everywhere, and of course, it's like some of them would write that limited stock offer is limited and all of that. But say they have one or two items in their catalog and they run this sale, would this be flouting this?
Yes, it would be, because they are effectively advertising a certain product that they want sold off their stocks. It would also be required that they clearly also mention, if there are any geographical restrictions. For example, that if an e-commerce platform is saying, I'm selling this, but tomorrow you get to know I can't purchase it in Nagpur, that needs to be mentioned. Or let's say you're selling a product which is only meant for 16 plus, you need to actually mention this, that this is only meant for the age group of 16 plus. So it is effectively tightening the ambit of what you're selling at a lower price needs to have very categorized explanations of how you're intending to sell it, what is the supply that you are intending to sell, and be very clear of who is it available to. And in case it is not available, then what are the timelines within which you are going to actually supply these products. So it makes it extremely stringent on everybody participating in this platform to ensure that what communication is being given to the consumers is very clear, very crisp, and very to the point, so that there is no dispute later on what were the terms of this. Now I'll just move on to surrogate advertising. Surrogate advertising is something that has always been around, and it is effectively the purpose of selling or advertising goods or products or services which are either restricted or as such prohibited in the market. So just to give you examples, things like alcohol and cigarettes, we cannot actually advertise in India. So you have always had the cost of, I think in the 90s when it started, the whole concept of surrogate advertising came in. When you have, just to give you an example, selling apple juice instead of alcohol is a very common way of surrogate advertising. Or let's say, popular drinks brand selling something else like a t-shirt, etc. That is what surrogate advertising is. And then you, of course, have banned products, let's say certain types of drugs, which you're not allowed to advertise at all. You cannot utilize that to become, let's say, hemp products, which have become very popular these days. You cannot use it as a stipulation to advertise something which is absolutely illegal in the market. So effectively, what they have given out for surrogate advertising, and this is something that always existed, so it's not new. They have only put it down as guidelines to probably expand the definition and make it even more stringent, where they say you cannot, first of all, try to sell something in the attempt of actually indicating something else. So to give you an example of it, you cannot display a bottle of alcohol and pour it into a glass and make it look like it is apple juice, because the effect is that for all intents and purposes, you're not calling it alcohol, but it is actually alcohol. Second is also what we call the second part of it is almost looking the same, the product. For example, you were to sell a non-alcoholic beverage, but the packaging of that non-alcoholic beverage, the logo that is used on it, the design elements on it, everything are identical to what you would buy if you were to buy the alcohol package. So you have many products that come in, non-alcoholic, alcoholic versions. This is a very popular thing actually in India to do. And the ability to advertise it is actually to show the non-alcoholic version. Now they have restricted it to say that you cannot use the same design elements, the same brand logo, you cannot use the same company name. If you do that, that is considered surrogate advertising. What they have, however, allowed in that spectrum is you can use the brand name and the company name if you are actually selling a legitimate product. So for example, if I was to actually sell a non-alcoholic beverage and use a completely different packaging, make it not look anything like the logo that existed in the original brand, and I was to sell it and it's a legitimate product brand, I'm allowed to do that. So they have actually defined this, which was not so defined to this extent. So we had a lot of misuse or advantage being utilized in surrogate advertising till date. The last thing that we'll come to is, of course, free claims advertisement, which is very popular, where you go and tell people that you're going to get this free. Like, for example, you're buying 10 things, you're getting something free against it. That is a very popular form of advertising these days, especially it comes to e-commerce platforms. It has become an extremely popular way of selling things, that you buy 3 products, you get the 4th product free. Now, when it comes to free claim advertisements, they have made it very clear that you cannot claim a product to be free unless it is actually free. And the only things that can be claimed to be charged in that aspect is, one, the cost that will be there for the person to actually reply to that advertisement. So for example, if he was to make a phone call, that cost of the phone call, if you're supposed to write in the cost of actually that postage, if it is actually a physical postage stamp. And secondly is the delivery cost against that product. So the actual delivery you can charge, that has been allowed. But what they have completely excluded is that you cannot charge people for, let's say, packaging of the products. You cannot charge people for, the handling of the product, that, the administration charges, which is a very popular, or handling charges, which is a very popular term that is used, cannot be put in. You cannot charge people for circumstances like if the actual free product that you're claiming is an element. For example, you're saying, I'm charging you for 4 things, the 5th thing is free, but the 5th element or that product's cost is actually covered in the product cost, you cannot claim that to be a free product then. Similarly, you cannot under any circumstances say something is free if the reply to that is it is going to be refunded. It is, limited use, that if you use it for 30 days, you're paying for the product, but you get money back. That is not considered a free product under law. So you cannot claim anything to be free in that circumstance. You also cannot make it to be free if it is only for the purposes of promoting the product, which is unessential. For example, you're just pushing something in which is not required for the product. It is not desirable for the product, but the purpose is only to entice the customer to purchase the free product. So these are the guidelines that, of course, they're far more detailed, and, and they give you the guide stipulations of what can and what cannot be done. But these are the 3 broad categories of definitions that have been brought in, and even terms and conditions of what can and not be done. And this would apply to everybody who's involved in the advertisement profession, including the social media influencers, etc., who will have to actually display these things when they make their ads, which is going to be a difficult purpose considering most of their reels are about a couple of seconds long. But this is what the requirement will be when they do.
Right. And we come to the, due diligence part later. But Namita, really practically, how do you see this spinning out for celebs, influencers? What would be your advice to them at this point with so much going on? Everything could probably be a potential, notice coming in. What would you suggest, people to do in this scenario?
I think there are some very basics. First of all, know the product you're endorsing. Don't just sell things for the purposes of selling things. Be aware of the company and the person you are working with, which I think in the last few years, people have been very unconscious. And I think this is not going to so much impact the bigger influencers and celebs because they already do the necessary due diligence, they do the necessary respects and they are largely guarded. It's actually going to impact the smaller influencer market, which basically do this as literally you have the 19-year-old who's doing an influencer bit and is selling anything and everything that is being given to them. The requirement will be to actually regulate what you are saying, how you're saying it. It makes the company liable. It makes the advertiser liable who's giving them the script, and it'll also make the influencer, who in many cases does not have a script or does not actually have an advertising agency vetting or padding this, it will become their responsibility to do so. And I think it's an important step in this day and age that we become conscious because of the kind of products and the loose lines of what is defined and undefined that has been going on for so long. I think there is a requirement of quality and quantity to be actually now put in as the forefront. The consumer needs to be important in all of this.
Right. Thank you so much, Namita. That was really nice to know. Bishwajit, coming to you, there are these elaborated, guidelines. There's also much done for children, advertising for children. I think that was a really welcome change to see. The consideration that has gone into framing these clauses as to what can be aired at what time, and then, during a children's program, what junk food ads are not to be shown. Could I know more from you on that, and what do you have to say?
Sure, Ashima. I think this is one of the most important things that this guidelines bring about, and it's quite a detailed provision. Specifically, guideline number 8 is what deals with children-related advertisements. We have to be mindful of the fact that there is one side of the business is that you have a manufacturer or a service provider who uses an influencer or an endorser to endorse his or her product. That's one part of it. The target is ultimately all the consumers. Now, the position that the manufacturer or the endorser holds is a position of power where whatever they are saying is largely believed by the people who follow them. Now, when it comes to children, while as opposed to other people, one can still expect an adult to understand, maybe do some sort of due diligence, understand the product, read up, and then perhaps you can still expect them to either believe what is being said or not believe. But for a children, I think the onus, and rightly so, on the guidelines has been put on this side of the people, that any advertisement that deals with children should actually be done with a lot of care and a lot of caution. Having said that, I would want to go a little slow on this. It's quite detailed and very important for everyone to understand as to what is it that this guidelines wants you not to do. So to begin with, that the endorser or the advertisement should not have a content which actually encourages some behavior or some action or some play which can actually be dangerous for the children, because children without realizing they copy such actions which can be dangerous to them without even realizing that this can even be fatal or can cause serious injury to them or to others. So therefore, one has to be very, very careful when it comes to this aspect, that you simply avoid and see whether this action will be dangerous for the children. So you stop that. You don't do that. It's as simple as that. Then, I mean, children are, again, as I said earlier, don't have the benefit of experience, right? So you can't take advantage of that. And therefore, I mean, maybe something that adults can do, children will simply emulate that. So you, again, don't do any such thing which, I mean, may impact children in a different manner. Now, similarly, again, as I said earlier, that for an adult to understand that this bit of it is what is real about the product, but it is quite common for people to exaggerate the features of the product or the services or the goods. But children would not have an understanding. So someone claiming that if you drink this, you become tall in 3 days. So an adult may understand that this is not possible. But for a children to understand this may be difficult. And the children may push their parents or find money to buy something which is completely unrealistic. So therefore, this is again something that is strictly prohibited. Then things that are detrimental to children's physical health or mental well-being are, again, you should not do it. Then at times, I mean, you see quite commonly that things like body shaming, someone is fat, someone is thin, someone is tall, someone is short. You don't come up with any advertisement which makes fun of people, where someone who has that kind of a body is ridiculed. So even such kind of advertisements are strictly prohibited. Then you don't come up with an advertisement where you'd expect children to go back to their parents and say that, look, this is something that was shown in the ad, so therefore you should buy it for me. So you have to actually be very, very careful when you come up with such advertisement. Then any other laws. It's also not just that. If there is any other law, I mean, it can be in relation to food, it can be in relation to any other. You have to be careful that if it is in violation of any other law, this is not just for children. The advertising has to be in compliance with any other law for the that is in force. Specifically, you cannot encourage tobacco or alcohol-based products for children. Then, if there is any product which any person from the sports field or music or cinema is endorsing, it should actually have a health warning for children if it has any health impact on them. So overall, I would say that it is important that the onus is on the advertiser to be very, very careful that they do not do anything that may have a negative impact on the minds and body of the children. You may have a negative opinion about your body image. You should not try selling something which is actually beyond their age. For example, there's a clear prohibition on advertising junk foods, chips, carbonated beverages, any such other unhealthy food or drinks in a program which is specifically meant for children or on a channel which is specifically only for children. So again, similarly, you should not sell a product or advertise something which offers that, okay, if you buy this, this is something that you'll get a toy for free. So you cannot even do that. So overall, I would say that this is a very, very welcome change, that the guideline takes onus in the sense that insofar as children are concerned, we will be very, very protective about them. And you have to be careful. And at a personal level and at a professional level, I would say that if there is a doubt when it comes to the guidelines in relation to the children, you actually are on the side of caution. Don't go there, because that this not only will have penal consequences, but will also result into a lot of problem in kids. So you have to be very, very careful about this.
Right. So, Vishwajit, you mentioned no free toys to be, used along with products. Now, there are meals that get sold like that, with a toy in that and all of that. Would that also be a part of this?
So if you're actually selling it and offering something for free, that's a different matter. That is not prohibited. That is not the subject matter of this guidelines.
But that's the idea, I think, is to attract people to buy that, or children, to go for that meal.
Absolutely. So the idea is that when they go to a shop, then you are offering something for free with that product. That's a different matter. But you cannot advertise that if you buy this product, you get a chocolate with it, you get a toy with it. So you can't advertise that aspect of it. So it is only on advertisement, not on actual sale. You're free to sell and offer for free that you want to. But insofar as advertisement is concerned, you can't do that.
Right. Thank you, Vishwajit, for clarifying that. And I think I quite like the fact that they've gone so in deep about how advertising should be around for children. Also, another question on, children who are celebrities or influencers. Where is the liability? Is that on the parents of the kid celebrity, or is it again on the people who are, the advertisers or the people behind the product? I think we've lost connection with Bishwajit. While Bishwajit, are you there?
Sorry, I think.
Yeah, I think there was a snag. So I was just asking that, for children celebrity and kid celebrities, the liability would be on the parents to see that they're, what they're doing, what they're advertising, or is it on the advertising agency to ensure that due diligence is done on their part?
So in this case, the onus is on both the advertiser as to how they use children for their advertisement. Similarly, even the parents will have the onus to look into it. They have to be careful as to what they are selling. So I think on this aspect, both sides would be responsible. The adults are responsible.
Right. Thanks, Vishwajit. So, another responsibility on parents now. When I coming to you, this looks, I mean, which is a good thing. This looks extremely consumer centric and consumer friendly. But do you see any kind of disputes coming out of this, maybe between the advertisers and the endorsers, or do you predict a rise in the consumer disputes? People are out to sue each other. What is in the offing? Sorry, Vinay, requesting you to unmute.
Yeah, am I audible now?
Yes.
Perfect. Before I actually address your question, I was going through the ASCII's 21-22 complaint report, and which we were discussing, before we all gone to live. It would be interesting to actually see the facts in terms of, as compared to previous year, there's been a 41% increase in misleading ads, especially featuring celebrities. Now, 92% of those ads that was processed by ASCII were found to be violating the code. 94% of the overall ads which were processed definitely needed some modification. And you'll be surprised that the most complained category by the consumers was education, where it tantamount to 33%. Now, coming to the question, whether would I, do I predict a rise in the consumer disputes? I would like to believe that, with these stringent regulations, we may actually see some, diligence coming in by the stakeholders, and definitely, certain stringent, because all of these statistics are pre-guidelines coming into force, right? Now, with these guidelines coming into force, being an optimistic person, I'm hoping that, you would definitely be, more, if I were to say, the statistics were to go down. But of course, given the responsibilities and duties which have been imposed on each of the stakeholders, right from your manufacturer to your service providers to your endorsers, of course, notwithstanding, the obligations which are being imposed on them, I am hopeful that it may not be as alarming as how it was, prior to these guidelines coming into force.
Right. Thank you so much, Vinay. You mentioned that there was a rise in at least violation. Now, how do you, comply with something like this? Something that I asked Namita as well. What are your thoughts on compliance? How can people be more compliant with it?
No, so when you mean people be more compliant in terms of
Celebrities, the advertisers, everyone else, I mean, the layman, so to say, what would be your advice to them in order to ensure that they're on the right side of the law? What would be a practical way to carry on?
You mean the concerned stakeholders to whom the guidelines are applicable to?
Yes. So we're talking about the celebrities or children. And
right. I think in that sense, the guidelines are very clear in terms of what duties and responsibilities each of these concerned stakeholders have to comply with, right? I think to the extent of even carrying out due diligence, as Vishwajit, said, as Namita has already, said, that while, from a company or a service provider perspective, there were certain elements which are already present, to the extent of surrogate ads, etc. I think by virtue of these guidelines, they've just made it more stringent and made it more clear, So I think that the question that effectively what you're asking is in respect of the concerned stakeholders, where at the end of the day, they need to comply with effectively what the guidelines are requiring them to.
Right. Thank you, Vinay. Thank you so much. Kaustubh, back to you.
Namita, I'd like to ask you, these guidelines are in addition to the Press Council Act and the Cable TV Network Regulation Act. So do you think this would overlap or create a confusion?
Not really. I think there are, the guidelines are actually to many extents far broader than both the Press Council Act as well as the Cable Networks Act. First of all, the Press Council Act is only effective to print media. Anything which was on newspapers or journals, etc., and effectively was actually a guiding factor towards newspapers and journalists as for the way in manner in which newspapers were supposed to publish. They do touch upon advertisements, and they do have guidelines to effect as far as what can be advertised in a newspaper and what cannot be advertised in a newspaper, but they were never so broad. And effectively the piece, which is the Press Council of India's powers, were also quite limited as to how and when they were to enforce it and in what manners that this enforcement was to be done. Further, it's also a very limited audience of what they were trying to regulate. Same with the Cable Networks Act also. It also relates to only largely cable networks or broadcasters as such, what it covers. So therefore, that is where the limitation would arise, and also what stringent actions were to be taken were also effectively only limited to these, what fell within the category. As far as how a court views it tomorrow, that yes, if there was an overlap as far as whether there's going to be double penalty, for example, if a violation under the Cable Networks Act also complies to that of under the guidelines, most of the time courts tend to look at this as a holistic aspect. They will look at it to look at a broader aspect of what is the actual penalty. You might in some cases, if they are separate offenses under both acts, actually have penalties under both acts. Whereas if you have, a certain offense, which is a penalty probably because they overlap, a court would probably interpret it to probably give it a holistic sense and may not give it a double implementation as far as penalty is concerned. But it will have to be seen how it will be interpreted. But the scope personally, I think, is far more broader and probably covers a lot more. So how much of the overlap is actually going to be seen is going to be, I think, quite minimal in what is going to be actually achieved by implementation of these guidelines.
So if I may just add on to what Namita just said, I think also one underlying principle that needs to be sort of, distinguished when we're talking about the other laws vis-a-vis these guidelines. These guidelines are stemming out of Consumer Protection Act, right? So to the extent that it's sort of affecting the consumer is when these guidelines kick in, right? So what in a sense I'm trying to say is that while all of these above laws, to the extent of what Namita mentioned, which are meant to curb the false and misleading advertisements, are enforced by different enforcement agencies and regulators. The Consumer Protection Act is the only law that gives the consumer the right to seek redress against such advertisements. So even that needs to be sort of kept in mind when we're discussing about any sort of an overlap of, the existing laws that are there.
So this is more of a special provision or a guideline. So this will take, precedence.
Yeah, it sort of addresses the concerns of consumers.
Yeah, right. So when I also, there's a mention of claim and, the disclaimer that these agencies put out or ads put out. Now, it's interesting to see how they see that it should use the same font or it should be on the packaging, the similar place, or even the voiceovers that are done for certain ads need to be in the same, at the same speed. Now, is that practically possible? What are your thoughts, and what else do people need to know about this provision?
No, I think with these guidelines, more than it being practically possible, I think now it's been, a legally mandate guideline that these companies will have to follow, right? I think guideline 11 sort of, spells out, what disclaimer and advertisements need to fulfill, right? And one of them is basically that it needs to be in the same language as the claim has been made in the advertisement. The fonts that are going to be used in the disclaimer shall be the same as that is used in the claim. The placement of the disclaimer shall be at a prominent and visible place on the packaging. So I think, look, the intent, as I said, right, is to protect the consumer from being in any way being misled, right? So to address your question, whether, whether it is practically possible, yes, now they have to legally follow this so as to ensure that, the consumers are not being misled otherwise.
So you think we'll see a change in the ads that we see generally, like in insurance ad, which has all these things, and then there's a very fast-paced disclaimer that goes.
Which I think they already have. I think now, if you hear any of these mutual fund ads or insurance ads, you'll actually understand what they're saying as opposed to, it going in a zippy.
Right, Vinay. Thank you so much. So, Bishwajit, coming back to you on understanding material connection and due diligence, something that words we've been using throughout the session, but what do they really mean?
Right, thanks. So this is actually something that is important from the endorser's perspective. So first, I would talk about material connection. So when you are endorsing a product, you may have some stake in it. So for example, you may be a shareholder of the company that is manufacturing that product, or you may have some other connection. Your immediate family member have some advantage in endorsing that product. So material connection would be that connection which benefits you. You have some stake in that product or services. So the requirement is that you'll have to disclose that so that people know that if I am endorsing or XYZ is endorsing a product, he has some stake in it. So he's doing it for some benefit directly that is associated with the increase in sales of the product. So a disclosure has to be made. That's the material connection part of it. The second part you said is to what is it that they need to do, due diligence that they need to do. Now, it is, I think that's something in a way, the endorsers being told in advance that, look, if you do this, this is going to be your defense. So to begin with, this is something that should be done. So when someone approaches you to sell, for you to endorse a product, then you need to know the product. I mean, those days are gone where you could simply act in a movie and you be there, you do your role, and you are gone without even understanding what is the product about, whether the claims being made are right, wrong, whatever is being said. Those days are gone. You have to understand the product. So if you say that I have used it, then you should have actually used it. You should have experienced it. So it should reflect your genuine and reasonable current opinion, which means dated opinion. It shouldn't be that 10 years back, some people thought something about something, that this was considered to be a good product 10 years back. Therefore, I believe that that shouldn't be there. You should be updated with the latest research, updated research on that aspect as to whether what you're saying is right or wrong. And it shouldn't be that someone just told you and believed it. You have to yourself be very careful as to whether what is being told to you is right or wrong. So for example, if it's a product which deals with some medicinal product, then the endorser should necessarily ask for a doctor's written view on that, so that he can rely on that, because we can't expect a celebrity to be an expert on everything. It can be a food product, it can be a health product, it can be some clothes. So you should take a written view and understand it. It's not just a mere formality that, okay, I've taken an opinion from a doctor, I'm fine with it. If he's fine with it, I'm fine with it. Still, the onus is on him to understand the product, experience the product, and only then say that this is what I believe about this. This is what it does. So technical backing plus factual experience-based backing is something that is required. It also comes handy tomorrow if there is some proceeding that is initiated with respect to that advertisement. So insofar as the celebrity is concerned, he should be in a position to say that I did my part of due diligence. I looked at these materials. I experienced it. Therefore, only then was I able to talk about this. It was not something in the air. It was not something that I simply believed without any diligence on my part. And as Namita in the beginning clearly said, that in some ways, I think this works well for the well-paid or the celebrities who are the leaders in the field. But insofar as the smaller influencers are concerned, they may find a bit of a challenge, because one, they can't impose terms on the people who are approaching them as to I need ABC. Secondly, they may not have the wherewithal to understand the product themselves. So it's a bit of challenge. But having said that, since the whole idea of the Consumer Protection Act and these guidelines is to protect the customers, so maybe it may seem to be a challenge for people who are into this business. But having said that, for the purposes for which these guidelines and the code has been notified, I think it is trying to achieve that, and also giving you a way out. It's not that you are left in lurch as to how do I go about it. So you now know what are the things that you can do, so as to things that you can do which will come to your defense if you face a problem later.
Right, Vishwajit. Very fine example that you used, but more on that, some examples come to mind. And For instance, there's a hair color. It says there's no ammonia hair color. Now somebody will say it's fat-free chips or something. What kinds of or levels of due diligence one would be required to do? And is it okay to say that, the advertiser or anyone who's approaching you that, hey, I want this supplemented with the due diligence or documents, relevant documents? Or is it on me to personally now go out and check that the color I'm endorsing is actually ammonia free, the chips that I'm endorsing are fat free? How will this really play out?
Fair enough. So to make it simpler, we see a lot of food products, and they actually are supposed to describe in detail on their packaging as to what are the contents of it, right? So none of us actually really know as to whether it contains that or not.
Yeah.
But the idea of the description is that tomorrow, if someone, for example, someone under the Food Safety Act does a check, they can confirm that this is what is contained in the whatever box or whatever it is. Similarly, so if someone is approached for an advertisement, now he or she cannot actually know as to whether if they're saying that it has ammonia or not. They can't technically or physically verify that. So they need to have clearly in writing from the endorser, and if it is a technical matter, then from a technical expert in that field. So he need not maybe appoint someone on his own to have that kind of a view or a certificate, but he needs to insist that, look, this is something that I want from you. I need to have it in writing before I stand up and endorse this product.
Right, Vishruti. Thank you so much. That I hope is useful to any influencers out there who are listening in right now. And
I think Ashima, also to sort of add, my apologies, also to add, what Vijay said, in terms of the question that was asked on disclosure of the interest. I think also the intent of the guidelines to add this requirement is so that, tomorrow the influencer or the endorser may simply not come out saying that, I am just simply an endorser. The regulators or the authorities know that there is a skin in the game over here. The fact that, there is an interest which you have in that particular service or product. So are you trying to say that, you've not conducted or you've invested in a product or a service where you've not done your due diligence, right? So that is also one of the rationales why, this needs to, so it's more like a double-edged sword for the endorser / celebrity.
Right. Thanks, Vinay, for adding that. Costa, back to you.
Vinay, if you could tell me, like guideline number 13 prohibits terms like up to or as low as. So if you could elaborate what other terms could be interpreted as part of this list.
Sure. So actually it's guideline number 12. Guideline number 13 is on due diligence. But you're right. I think, effectively these terms have been added or rather, this forms part of the duties of the manufacturer / service providers to ensure that, the advertisements in effect don't make any claims which uses these expressions. And I think the intent is clear that, in case if there is a fixed period of guarantee or there is a fixed price of the product that is there, that needs to be clearly stated upfront, as opposed to you putting up saying that up to 5 years or prices from as low as. So again, I think the intent of the guidelines are very clear that whatever is there, it needs to be either in black or white, and it needs to be put upfront to the consumer, again from the underlying principle being that not to be misled.
Right.
Vinay, do we know more expressions that would be part of it? I mean, what else can we think of?
No, so I think the easier way to sort of answer that would be that any terms which do not address the essence of something not being upfront would be the wrong terms to be using it.
Right. Thank you, Vinay. Thank you so much, panelists. Audience, if you have any questions for us, please do send them to me on the chat. And in the meantime, I would like to wrap this conversation by going around the table once again. Namita, back to you on anything else that you'd like to add to this for our influencers in specific. Also, if they receive a notice, what should they do?
Well, for influencers, I would say just become more careful on what you're endorsing and how you're endorsing it. Do your checks and balances when your company approaches you, especially when it comes to products which are used, whether either ingested or used on face or body, or where there are claims. I think the more important factor is when you have claims which are, this is the best in line, this is going to improve your skin tone to X value. I think it's very important for influencers to do the checks and balances, back it up with material, ask the basic questions that, what are the basis of these claims that you are asking us to do. And, I think it is, if you get a notice, it's as simple as that. You might have to go to a lawyer. I think that's as simple as the question is, because it is a very, to some extent, a guideline which will also need some interpretation as time goes by. And also the consequences of it are quite severe. So I don't think anyone can take it too lightly if they do manage to get a notice under this.
Right. Thank you, Namita. Word of caution to all influencers. Bishwajit, back to you. And what would be your thoughts on what are the other things that can happen with an influencer or a celebrity? A notice is one of those things, but you said bans and other things. So where does the redress lie?
So I think before I answer that question, there is a clear regime change in the sense that one position was that buyer beware. Now, in this perspective, I think the seller and then also the endorser beware, and rightly so, because they are sitting on the information. No one knows a product better than the manufacturer. So the celebrity or the endorser is in a position to ask those questions, because insofar as the power equation is concerned, the celebrity is in a position to demand that this is what I need and you will have to give to me, because the manufacturer needs that person. He wants someone to endorse. And if there is a unanimity amongst the endorsers, I think the manufacturers will be bound to follow that they will be careful. They can't simply pass on the buck on someone or the other. So responsibility will be fixed. Now, coming back to what all should the celebrities be beware of later. So first thing is, I think best is prevention is always better than cure. So I think you need not approach Namita, Vinay, or us. I think that would be the best position for the endorser. But having said that, if you get a notice, then you better be advised by a lawyer, because at times you may not know and put something in writing which may become a problem for you. So you approach a lawyer, and I am sure there will be people and lawyers who will guide you step by step as to how to deal with it, when to deal with it, where to deal with it. Right. So the right forum, we know there is an authority. We know you go there at the stage of investigation. When it goes to court, you go to consumer court. So broadly speaking, you have the forum, you know the agency. You may not know everything, but I would in fact add take a step back and say that it's best, if possible, you should be advised by a lawyer at the beginning itself, because you may want to have an agreement with the manufacturer or the service provider, which provides you that there will be an indemnity clause. The manufacturers will provide you with a lawyer of your choice, and the cost will be paid by the manufacturer or the service provider, because it's not really the fault of the endorser, because at some level, he rightly, wrongly is believing on the manufacturer. The manufacturer may provide all the information, but again, for a influencer, possibly because of their lack of technical expertise or because they stay busy, they may not be able to either negotiate or ask the right kind of question, ask the right kind of information that should be required to be asked in the beginning. So my suggestion would be that from that stage itself, if you have a lawyer, you will have a template in place as to what kind of questions, what kind of information to ask to prevent any problem in the future.
Right. Great advice, Vishwajit. Also, can liability be shunned away by an agreement? If I say that, you take the responsibility, I shall not be held responsible for anything, any notice that comes. Can I put that as part of my contract?
So
no, you can't do that. Sorry, it
Yeah.
was, you want to answer?
No, go ahead. Go ahead, Vishwajit. In fact, I was going to touch on that topic itself. I mean, you may have indemnities in the contract, or, most likely you're going to see endorsement deals becoming much more expensive now because of these guidelines, right? But at the end of the day, one has to be conscious that these guidelines also put an obligation independently on the endorsers, right? So while you may seek a contractual indemnity from the company, you are still fighting your own battle with the regulatory authority.
So I'm sorry, I lost that part. So can I really, when I'm engaging with a company, say that, hey, if anything comes, this is not my responsibility, I'm not liable, or can I not?
No, you cannot.
You cannot.
But what you can
It's a
cover yourself
back-to-back
for is,
indemnity. Yeah.
is you can probably cover yourself to the extent that, let's say, a company does give you all the reports and everything that may be given, but however, that information is false, because nobody expects an endorser or an influencer to actually have scientific or background in the particular field. But what you can cover yourself is that, in spite of me doing my basic due diligence, if information provided by the company or the manufacturer or the advertising agency is incorrect, then you can be covered and indemnified to that extent. And in most likelihood, a court will view that in your favor, because that is how it is seen. The purpose is not to stigmatize or penalize endorsers for anything and everything. It is to just make them responsible that what they say is correct and not correct. And it should be so, considering, I mean, just basic numbers, it's a $9 billion industry today to influencer market. It's going to grow to $22 billion in another 5 years. We're looking at numbers and income that is coming through this market, which is very high. So it is just to ensure regulation. It is not to intentionally penalize with no purpose.
Right. Thank you, Namita. I think it rightly tightens the noose on all these misleading ads. So great change. Thank you so much for bringing us the insights. And it has been so wonderful to have this session with you. Thank you so much once again for joining us.
Thank you so much.
Thank you, Ash. Thank you.